My good colleague, my friend, my senior counsel called me Danstan Omari a buffoon. We file a petition. We file our case at the disciplinary committee. When the decision was for him to take plea, he rushed to the Judicial Review Division, and that plea was deferred. Let us not have a double standard. The scales of justice that for advocates, when we get interim orders to stop our prosecution, are the same orders the judges are enjoying. Let us not only see the scales of justice when they favor advocates, but when they favor the judiciary, we are blind to that. Is the Law Society of Kenya right to call for this strike against these judges? Myself, Danstan Omari, I'm a member of the Law Society of Kenya. We cannot discriminate the judges and judicial officers, yet the Law Society of Kenya advocates have court orders allowing them not to be charged. So, in my take, this is not a wise decision. If tomorrow the courts will be sitting, and the judiciary has given it very clearly that the courts will be sitting, those advocates will not be attending your client's wrath. I don't know how you'll deal with it. Welcome to trending news about Court Helicopter. Tomorrow, the Law Society of Kenya has called for a nationwide strike against judges who have court orders suspending either their investigations or they are being asked to appear before the Judicial Service Commission. This is a serious issue, and it has serious ramifications to the administration of justice and dispensation of justice in this country. 13 judicial officers, including all the 7 judges of the Supreme Court, that is the Chief Justice, the Deputy Chief Justice, and all the other judges, are implicated in this onslaught. Court of Appeal judges, High Court judges, and magistrates are part of the team. The reason the Law Society of Kenya has called this onslaught is that these judicial officers went to court and stopped either their investigations, their disciplinary process before the Judicial Service Commission, or the investigations that are being conducted by independent investigative agencies like the EACC or the DCI. 13 issues arise from this question. One of them is, what are the constitutional provisions that the Law Society of Kenya has violated? Is the Law Society of Kenya right to call for this strike against these judges? Myself, Danstan Omari, I'm a member of the Law Society of Kenya. Article 10 calls for active participation. Was there enough sufficient public participation amongst over 22,000 lawyers to arrive at this decision? The answer is a definite no. Number 2, are judicial officers, citizens, or private people who are allowed to access the courts? Can we say, once you're a judicial officer, you cannot be a party in a court? You can't be a litigator. You can't go for rights of access because you dispense of justice. Those are the fundamental issues that we shall be looking at, why this issue is there. Free. We are looking at what orders the courts have given them. These are judicial review orders of certiorari. In certiorari, somebody moves to court to quash the decision either to charge him or the decision to appear before a body. They also have gone for orders called prohibition. Prohibition orders and certiorari orders are orders that are given by the Employment and Labor Relations Court, Judicial Review Court, and also the Constitutional Court. They are meant to stop the illegal or powers that are being exercised wrongly by administrative bodies. The Judicial Review Division is an administrative body. The DPP makes decisions as a public administrative body. So once that decision has been done, you can rush to the court and challenge the procedures the JSC, the EACC, the DPP used to arrive at that decision. Those are what the orders the judges and magistrates have. Are they all the only ones who have these orders? No. How many advocates have been investigated by the EACC, by the DCI, a file gone to the DPP, and the DPP has approved these charges to be preferred against them? The same advocates rush to the Judicial Review Division of the High Court or the Constitutional Division of the High Court, and they get those orders. Have the judges refused to listen to those advocates who have court orders stopping their prosecution? The judges have not refused to that. Is this a double standard? Why will judges who have similar orders be dealt with differently from the advocates who have court orders stopping their prosecution, stopping their investigations? This is a doublespeak. And to that, Article 27 recognizes that everybody must be dealt with on equality basis. We cannot discriminate the judges and judicial officers, yet the Law Society of Kenya advocates have court orders allowing them not to be charged. We look at the law and the constitutional provisions that have been violated by the call by the Law Society of Kenya for this. This is when you look at the Bill of Rights. In the Bill of Rights is the Bill of Rights, that is chapter 4, available for the judges and judicial officers, or it's only available for advocates and for other citizens. The law talks of Article 24, the limitations of rights or fundamental freedoms. You cannot limit the fundamental rights of judges and allow the others. Article 25 talks about the fundamental rights and freedoms that may not be limited. Is Article 50, the right to a fair trial, available also for judges? Yes, it is not only available for advocates. We talk about equality and the freedom from discrimination in Article 27. Are judicial officers being discriminated by virtue that they are judicial officers? Is this an attack against their fundamental human dignity in Article 27? Yes. To Article 28? Yes. Then we are looking at the issue of fair administrative action, Article 47. Were the judges summoned to the Law Society of Kenya Council to defend themselves? They were never given a fair hearing. They were not heard. Article 48 talks about access to justice. Can you deny access of judicial officers to courts because they are judicial officers? Access to justice is a right to everybody. Whether you are a Kenyan, whether you are a judge, whether you are a foreigner, so long as you are within the jurisdiction, territorial jurisdiction of Kenya. So this violates access to right. Fair hearing. Article 50 provides for a fair hearing. Was this granted to the judges and judicial officers? There was no fair hearing that was allocated to them. Then we go to Article 159. In Article 159, we are looking at the creation of the judiciary. The judicial authority is created by the Constitution of Kenya. Did the judges that granted the orders of conservatory orders, were they acting against Article 160? No. The independence of the judiciary. We should respect the independence of the judiciary. If a judge granted the Chief Justice an interim order, the aggrieved party could move to the Court of Appeal. If they're not satisfied, the Supreme Court. That is what is there, not calling for late advocates not to go to courts. Then we have in Article 162, the creation of the Employment Court. That court is not an exclusive court for only citizens. The Employment and Labor Relations Court is a court where advocates appear, where judges are parties and everything. So the question that Court Helicopter Danstan Omari is putting across, can judges, when their relatives die, can they appear as a party in a succession matter? Why will you allow a judge as a party in a succession matter? Why will you allow a judge or a judicial officer as a witness in a criminal matter? Why will you allow a judge who has been arrested to be tried before a court that is there? Why will you allow a judge who has a commercial case or a magistrate who has a commercial case to appear as a party before the courts of law? So, in my take, this is not a wise decision. Several advocates, we looked at Professor Petition number 470 of 2018. This is where Professor Ojenda, currently the senator of Kisumu, was arrested and was being arraigned before the courts. The High Court stopped that prosecution. Why didn't the advocates now raise that issue? We have also petition number E273 of 2021. Justice Murina stopped the prosecution of then President of the Law Society of Kenya, Senior Counsel Nelson Harvey, and very many others. My position is that it is wrong. We have the decision of where Justice Kantai Ole Sankare was supposed to be charged. That matter was concluded and the judge, Justice Mwita, cleared any criminal charges against Justice Sankale. So what I'm saying from Court Helicopter, let us be equal to the law. Some of those 13 are clients. All of them are clients of advocates. Is the Law Society of Kenya going to discipline the advocates who represented the judicial officers to get those orders? Unless those advocates are disciplined. I know myself, I have 2 clients in that group? Am I going to be disciplined because I represented them? Did the judges get the orders available by statute and by constitution? They got orders known by law. So, on my own, it is uncalled for. It is treating our brothers and sisters in the judiciary differently from how we, the lawyers, want us to be treated. I know this is a very controversial position that I've taken, but my advice is that no judge has instructed you as an advocate. Only clients who have paid your fees. And remember, failure to appear in court as an advocate because you are not providing legal services that you have been paid for. Nowhere in the contract for you to be retained as an advocate is there a clause that you can refuse to appear and represent your client. Some courts, if a date is given, it takes another 6 months or 1 year to get another date. If tomorrow the courts will be sitting and the judiciary has given it very clearly that the courts will be sitting, those advocates who will not be attending your client's wrath. I don't know how you'll deal with it. This is the trending version. This is my position. Wakili Danstan Omari, this is not the right way to deal with grievances. Why shouldn't we allow independent institutions created for that purpose? The Law Society of Kenya has no mandate at all to discipline judicial officers. It has no mandate to hire. It has no mandate to promote. The Judicial Service Commission, an independent commission, is sufficiently enough. The Law Society of Kenya has 2 members, a female representative and a male representative. In JSC, we are ably represented by those 2 members. If there is an issue, they should raise it from within. Law Society of Kenya cannot elect its representatives and purport to have powers to discipline the judges and magistrates. Wakili Danstan Omari, all that I'm saying, the scales of justice that for advocates, when we get interim orders to stop our prosecution, are the same orders the judges are enjoying. Let us not only see the scales of justice when they favor advocates, but when they favor the judiciary, we are blind to that. Kenyans will remember when I went to defend Dr. Fred Matiang'i when he was being arrested, and the DCI investigated me, wanted me charged. Had I not rushed to the Judicial Review Division to stay that prosecution, I could have taken plea. Very many advocates who have disciplinary cases at the disciplinary committee, they are enjoying those orders to stop the disciplinary committee from dealing with them. Very many advocates, and I'm not ashamed to say, we are not less than 1,000 who have those orders either quashing or staying the prosecution, either at the disciplinary committee or being charged or everywhere. Those are the orders everybody enjoys. Anybody targeting the judiciary is targeting the judiciary